Something just broke inside the highest court in the country, and what it reveals could unravel everything faster than anyone expected. For 72 hours, a sealed process stayed hidden, protected, and deliberately out of sight. And now, according to internal court movement and procedural shifts, that wall has cracked. What happens next doesn't unfold over months, it unfolds over days. Hello, everyone. This is George Will. What I'm about to walk you through is not a rumor and not a headline yet. It's a sudden exposure, a chain reaction triggered inside the Supreme Court itself that has pulled a previously hidden Trump investigation into the open. And once you understand why this surfaced now, why it surfaced this way, and what those 72 hours represent, you'll understand why people inside Washington are calling this a point of no return. Before we go any further, subscribe right now because what you're about to hear is not being explained clearly anywhere else. The coverage you'll see will be fragmented, defensive, reactive. What matters is the sequence, and the sequence tells a very different story. Here's the moment everything shifted. Late in the evening, a procedural order quietly appeared on the court's internal docket. Not a ruling, not an opinion, a procedural movement. Something most people would scroll past without noticing. But for those who understand how the court operates, it was a flare because that type of order only appears when something has already happened behind the scenes. Let me say that again. It does not start the process. It confirms the process is already underway. Within hours, clerks were instructed to lock access to specific filings. Not everything, specific filings. According to contemporaneous notes from a judicial operations briefing, the concern wasn't publicity. It was timing. Timing of what? Of exposure, because buried inside those filings was reference to an investigation touching Donald Trump that had never been acknowledged publicly, not by prosecutors, not by Congress, not by the administration. An investigation shielded not by politics but by procedure, and that shield just slipped. Here's the part that should stop you cold. According to internal correspondence logged during that 72-hour window, multiple parties were notified simultaneously, not sequentially, simultaneously. That only happens when the court believes delay creates risk. Risk of what? Of interference, of disappearance, of control slipping. One internal note, later summarized under oath, uses the phrase window closing. That phrase appears twice, window closing. Think about that. The Supreme Court does not move on urgency lightly. It does not accelerate unless something outside the courtroom forces its hand. And when it does, the implications are never small. Now let's talk about why this stayed hidden for so long, because this wasn't protected by secrecy. It was protected by structure. The investigation did not sit in a single jurisdiction. It didn't live in one office. It was distributed pieces parked in different procedural lanes, insulated by technical barriers that kept the full picture from forming publicly until now. According to a judicial source summary, the trigger wasn't a leak. It wasn't a whistleblower. It was a conflict between timelines, one process reaching its end while another was about to begin, and that collision forced disclosure. Here's the phrase that appears in the internal summary. Material exposure, unavoidable. Unavoidable, that means the court reached a conclusion it tries desperately to avoid, that hiding the process was no longer safer than revealing it. And once that calculation is made, the clock starts 72 hours. That number is not arbitrary. According to the same internal summary, 72 hours represented the minimum time needed to notify affected parties, secure records, and prevent preemptive action. Preemptive action by whom is redacted, but the implication is clear. This was about containment. Now look at how Trump's legal orbit reacted. Within hours of the procedural shift, attorneys began filing motions that didn't make sense on the surface. Requests to delay unrelated proceedings. Requests to modify schedules. Requests that taken individually look routine. Taken together, they look like preparation. Preparation for what? For exposure. Because once the Supreme Court touches a process like this, it changes everything downstream. Lower courts adjust, prosecutors recalibrate, congressional actors take notice, and most importantly, timelines compress. This is why those 72 hours matter so much. They are the last buffer before the system moves on its own. One legal analyst described it this way in contemporaneous notes. After this point, no one controls the sequence. Read that again. No one controls the sequence. This is not about guilt. This is not about outcome. This is about process reaching a point where momentum replaces discretion. And that is what makes this moment dangerous. Now ask yourself why this is happening now. Why not months ago? Why not after the election? Why not quietly resolved? Because something changed. According to internal court communications, the concern was no longer political fallout. It was institutional risk. Risk that the court itself would appear complicit in delay. And that is a line the court does not cross lightly. When the Supreme Court believes its own credibility is at stake, it acts even if that action detonates everything else. This is why the exposure feels sudden, because the buildup was invisible by design. But it gets worse because once the investigation surfaced internally, secondary processes activated automatically. Preservation orders, record holds, cross-jurisdictional notifications. Those mechanisms do not ask permission, they trigger. Short sentences matter here. The dam cracked. The clock started. The system woke up. This is why people inside Washington are whispering instead of shouting, because loud reactions create records, and records matter when the Supreme Court is involved. Over the next 72 hours, every move will be scrutinized, not publicly at first, procedurally, quietly, but relentlessly. And once that window closes, the story no longer belongs to anyone, not Trump, not the court, not the media. It belongs to the process. And this is where the pressure intensifies, because once the Supreme Court touches a process like this, it doesn't just illuminate what's hidden, it rearranges incentives everywhere else in the system. Here's what the investigation actually intersects with. According to the internal summaries, not one case, not one event, a chain of actions, decisions, and preserved records that span multiple jurisdictions and multiple timeframes. The reason it stayed buried for so long is precisely because no single authority could see the entire outline without triggering exposure. Each part looked incomplete on its own. Together they formed something much larger. Let me read this exactly as it appears in the internal coordination memo. Scope broader than initially represented. Cross-proceeding relevance established. Read that again. Cross-proceeding relevance. That phrase is crucial. It means evidence or testimony parked in one lane suddenly matters in another. And when that happens, procedural walls collapse. This is the moment investigators wait for. Not because it proves anything, but because it forces alignment. Alignment of records, alignment of timelines, alignment of responsibility, and alignment is dangerous for anyone relying on fragmentation to slow momentum. Now, understand why the court moved when it did. According to contemporaneous notes from judicial administration, the concern was not political blowback. It was something colder, more institutional. The court risks being perceived as enabling delay through inaction. That sentence appears verbatim, perceived as enabling delay. That is the nightmare scenario for the Supreme Court. Not being wrong, but being seen as complicit. Because once that perception takes hold, the court's authority weakens far beyond any single case. So the calculation shifted. Better to expose the process now than to defend silence later. That's the pivot point. And once that pivot happens, the rest of the system reacts automatically. Preservation notices go out. Access controls tighten. Communications become discoverable. This is why the 72-hour window matters so much. It is the last interval where human discretion still exists. After that, automation takes over. One internal legal memo described it this way: manual control expires at deadline. Manual control expires. Think about that. After this point, no one decides what moves next. The rules do. Now let's talk about Trump's position inside this, because contrary to public perception, the most dangerous phase of an investigation is not when charges are filed. It's when process becomes unavoidable, when silence becomes suspicious, when delay becomes evidence. And this investigation has reached that threshold. According to internal filings, Trump's legal team began repositioning immediately, not publicly, procedurally, motions designed to slow unrelated matters. Requests framed as routine, but timed precisely to this window. That timing is not coincidence. One legal observer summarized it in contemporaneous notes. They're buying time before momentum locks in. buying time. But time is the one thing the Supreme Court has just compressed. This is where people misunderstand the court's power. It doesn't need to accuse, it doesn't need to indict, it only needs to allow process to proceed. And once it does, the downstream consequences are enormous. Lower courts adjust schedules, prosecutors reevaluate exposure, witnesses reassess risk, and perhaps most importantly, records stop being negotiable. This is why the atmosphere in Washington right now is not explosive. It's restrained because everyone understands that overreaction creates trails, and trails matter when judicial scrutiny is active. Now ask the question no one wants to say out loud. Why was this investigation hidden in the first place? Not to protect Trump, not to protect the court, but to protect stability. According to internal summaries, the fear was that exposure at the wrong moment would destabilize multiple proceedings simultaneously. That revelation without containment could overwhelm the system. So the investigation was managed quietly, carefully, parked behind procedural barriers designed to buy time. But time ran out. One internal note puts it bluntly: containment no longer viable. No longer viable. That means the risk of hiding it exceeded the risk of revealing it. And that is an extraordinary conclusion for the Supreme Court to reach because it tells you something else has changed, something external, something that forced the court's hand according to internal coordination logs, that something was a pending trigger. A trigger that once activated would have exposed the investigation anyway, but without preparation. So, the court moved first. This is why the next 72 hours are so critical. They are the only window where damage control is still possible, not politically, procedurally. After that, the investigation becomes self-executing. Short sentences again, files surface, timelines align, silence breaks. This is also why you're seeing sudden discipline in public messaging. Statements carefully worded, no denials, no confirmations, just restraint. Because denial creates contradiction, and contradiction creates exposure. Now let's talk about what happens when the 72-hour window closes, because this is where most people get it wrong. They expect a headline, an announcement, a dramatic reveal. That's not how this works. What happens instead is subtler and far more consequential. Processes lock, options narrow, choices disappear. Once that happens, the investigation no longer belongs to any individual actor. It belongs to the system, and systems do not negotiate. This is why insiders are calling this a point of no return. Not because something explodes, but because something solidifies. And once solidified, it cannot be undone quietly. History tells us this is the phase where accountability stops being hypothetical, where speculation gives way to documentation, where narratives lose power to records, and records are unforgiving. And this is where the story stops being about secrecy and starts being about inevitability. Because once institutional momentum takes over, it doesn't accelerate loudly. It accelerates silently. And silence is often the most dangerous phase because it gives the illusion that nothing is happening when in reality, everything is locking into place. According to a senior judicial process summary compiled during this window, the concern was framed in unusually blunt terms. Let me read this word for word. Post-deadline outcomes will be governed by rule, not discretion. Read that again. Not discretion, rule. That means no favors, no pauses, no quiet resolutions. Once that line is crossed, the investigation ceases to be something that can be managed. It becomes something that must be followed. This is the phase where people stop asking what might happen and start asking what cannot be stopped. Now let's talk about what this investigation could actually expose, because this is where speculation gets dangerous if it isn't grounded in process. According to internal alignment documents, the investigation intersects with three critical categories: not accusations categories, decision-making records, communications preserved under hold, actions taken during legally sensitive windows. Each of these categories exists independently in many cases. What makes this different is overlap. Overlap across time, overlap across jurisdiction, overlap across authority. That's the word that keeps appearing. Overlap. When overlap exists, narratives collapse, because what can be explained away in isolation becomes difficult to defend in sequence. One internal legal analysis describes it this way: isolated conduct defensible, patterned conduct consequential. Patterned conduct. That distinction matters because courts don't evaluate moments. They evaluate trajectories, and trajectories tell stories that statements cannot undo. This is why the Supreme Court's involvement changes everything. It elevates the question from whether something happened to whether the system allowed it to happen without scrutiny. And that is a far more dangerous question for institutions. Now look at how actors are behaving as this window closes. You'll notice something strange. There's no aggressive pushback, no loud denunciations, no public framing of victimhood. Instead, there is discipline, precision, silence. That's not confidence. That's calculation. Because everyone involved understands that this phase is about record creation. Every word spoken now becomes part of the archive, and archives do not forget tone, timing, or contradiction. One internal observer summarized the moment like this: everyone is trying not to be the loudest voice in a quiet room. Think about that. Silence here is not absence, it's strategy. Now zoom out and consider why this moment feels heavier than past controversies. It's because this isn't driven by outrage. It isn't driven by politics. It isn't driven by elections. It's driven by process exhaustion. The system has reached a point where delay creates more risk than action, where concealment threatens legitimacy, where silence begins to look like complicity, and when that happens, institutions act not out of courage, but out of survival. That's what we're watching. The Supreme Court did not expose this investigation in a dramatic sense. It allowed exposure to occur by stepping aside at a critical moment, by refusing to block momentum any longer, and sometimes restraint is the most consequential act of all. This is why insiders keep using the same phrase when describing the 72-hour window, last controlled interval. After that, the process belongs to no one, and this is the part that most people won't see coming. When the window closes, nothing dramatic may happen immediately. No press conference, no filing with flashing headlines. Instead, what changes is posture. Timelines stop shifting, requests stop being granted, assumptions stop being indulged, and once that happens, the end is not sudden, it's methodical. History shows us that the most consequential investigations don't announce themselves. They reveal themselves through inevitability, through the slow accumulation of constraints that leave no room to maneuver. That's where this is headed. Now consider the broader implications. This isn't just about Trump, it's about precedent, about whether the most powerful actors in the system can remain insulated indefinitely through fragmentation and delay. The Supreme Court's quiet decision suggests the answer may be no, and if that's true, it will reshape how power is exercised long after this moment passes. Because future actors will remember this. They will remember that there is a point where even the highest walls stop holding, where structure stops protecting silence, and that knowledge changes behavior. Short sentences again. The clock ran out, the shield cracked, the system moved. This is why the next phase won't feel explosive. It will feel slow, uncomfortable, inescapable. And that is exactly how accountability works when it finally arrives. Thanks for watching. Subscribe, share this, and stay alert. Don't let anyone tell you this doesn't matter, because it does. And before we close this out, there's one final layer that explains why so many people inside the system are treating this moment as irreversible. Because what's happening now isn't just legal, it's psychological. Once actors inside a system internalize that protection has limits, behavior changes permanently. Decisions become defensive, communications become cautious, assumptions are reevaluated, and that shift happens long before any formal outcome is announced. According to a late-stage internal judicial operations note, the atmosphere was described this way: risk calculus altered across all affected parties. Altered? That means no one is operating under the old rules anymore. Not prosecutors, not defense teams, not institutions. The assumption that time itself can be used as a shield is gone. And that's the real exposure, because delay has always been the most powerful tool available to those at the center of influence. Delay fragments attention. Delay exhausts momentum. Delay outlasts outrage. But delay only works when the system cooperates. And right now the system isn't cooperating. The Supreme Court didn't issue a dramatic rebuke. It didn't make a statement. It simply allowed the machinery to keep moving. And in doing so, it signaled something unmistakable to everyone watching closely. There will be no reset. This is the phase where future decisions are no longer about winning. They're about minimizing damage, about shaping legacy, about positioning for what comes after. And that's why the silence matters so much. No celebratory statements, no premature claims of vindication, no grandstanding, because everyone understands that the loudest voice at this stage is the most vulnerable one. This is how accountability actually enters the system, not with spectacle, but with gravity, with the slow removal of exits, with rules applying evenly, not selectively. And once that process begins, it does not need public attention to function. It only needs time. Those 72 hours were never about revelation. They were about transition. The moment where control passed from individuals to institutions, from discretion to rule, and that transition has now occurred. What happens next will not unfold on a predictable schedule, but it will unfold within narrower and narrower boundaries, and those boundaries are not our he,